Your argument first this morning in Case 16-1466, Janus versus the American Federation of State, County, and Municipal Employees. Mr. Messenger.
Mr. Chief Justice, and may it please the Court. Abood should be overruled because it failed to apply heightened First Amendment scrutiny to a compulsory fee for speech to influence governmental policies. Abood's failure places it at odds with Harris, with Knox, and a slew of other speech and association precedents. Now, respondents attempt to justify Abood's results with rationales found nowhere in that decision, which undercuts any stare decisis value in retaining Abood.
May I ask, Mr. Messenger, if you are right about agency fees, what about three things? One is student activities fees. Are they different, and if so, why? Another is a mandatory bar association payments. And the third is you have a public sector case. What about the private sector, agency fees compelled by state law in the private sector?
Yes, Your Honor. With respect to the first two instances, the student association or student fees and the bar association fees, those cases are distinguishable for reasons stated in Harris. They're justified by different interests. The state bar associations are justified by the state's compelling government interest in regulating the practice of law before its courts. The student association fees are justified by the government's or what a university's compelling interest in setting up a viewpoint-neutral forum for speech. And then with respect to the private sector cases, they hinge on a question of state action. So in this case, only public sector union fees are being challenged. In the private sector, you'd have a question of whether state action applied, and therefore the rule of Janus would apply to that case.
I'm sorry. I thought that we had always recognized that the government as employer had a compelling interest in regulating its employment decisions. We permit the government to fire people, deprive them of all money, not just a fair share fee, but deprive them of any income if they speak outside of the government's approved policy messages or messages generally. So if we can permit the government as employer to have a compelling interest to do something as dramatic as firing someone, why can't that interest in having workplace peace, workplace routine in which issues are decided in a collective way, why isn't that a compelling interest comparable to the others?
Well, the government's interest in restricting speech don't apply to compelling support for speech. In fact, oftentimes they cut the opposite way. So the government's interest in restricting speech, for example, in the Hatch Act, restricting political activities, wasn't preventing the politicalization of the workforce and preventing government employees from being organized into a political machine. Of course, those same interests don't justify forcing individuals to support the speech of an advocate.
But that's no different than forcing student participation in fees to provide a public forum, to have a bar association regulated. These are all forcing the subsidization of private interest for a government purpose. And the government purpose here is labor relations and labor peace. Why isn't you still haven't told me why that's not a compelling state interest?
Well, irrespective of whether —
Or I shouldn't say state, a compelling federal government interest.
Yes, Your Honor. The Court doesn't need to reach whether or not labor peace into that such interests are compelling because agency fees are not a least restrictive means to satisfy any labor peace interest the government may have in listening to one union. So the labor peace interest, as this Court has explained it in Abood, is a government's interest in listening only to one union, so it doesn't have to listen to multiple.
Well, there's another way of doing student fees. You can have students who don't pay not participate in any student activity because the price of being permitted to participate. You can have bar associations that the state runs. You can have alternatives of all kinds. But the question is the alternative that the state has chosen one that is well fitted to its need? Is it well tailored, narrowly tailored? I don't see how you can do that given the interest of the government in ensuring that unions represent everybody.
Well, an agency fee isn't necessary for exclusive
Why
representation.
not? You have free riding.
Well, the reason, Your Honor, is exclusive representation in and of itself is a valuable benefit for a union. It provides unions with extraordinary powers to compel the government to listen to it at the bargaining table, to not listen to other advocacy groups.
But it drains it of resources that make it an equal partner in the bargaining setting. If you are right, then it's not only the people who are opposed to the union, but also union supporters who may think, I'd rather keep the money in my own pocket. And then you'll have a union with diminished resources, not able.
Your argument first this morning in Case 16-1466, Janus versus the American Federation of State, County, and Municipal Employees. Mr. Messenger.
Mr. Chief Justice, and may it please the Court. Abood should be overruled because it failed to apply heightened First Amendment scrutiny to a compulsory fee for speech to influence governmental policies. Abood's failure places it at odds with Harris, with Knox, and a slew of other speech and association precedents. Now, respondents attempt to justify Abood's results with rationales found nowhere in that decision, which undercuts any stare decisis value in retaining Abood.
May I ask, Mr. Messenger, if you are right about agency fees, what about three things? One is student activities fees. Are they different, and if so, why? Another is a mandatory bar association payments. And the third is you have a public sector case. What about the private sector, agency fees compelled by state law in the private sector?
Yes, Your Honor. With respect to the first two instances, the student association or student fees and the bar association fees, those cases are distinguishable for reasons stated in Harris. They're justified by different interests. The state bar associations are justified by the state's compelling government interest in regulating the practice of law before its courts. The student association fees are justified by the government's or what a university's compelling interest in setting up a viewpoint-neutral forum for speech. And then with respect to the private sector cases, they hinge on a question of state action. So in this case, only public sector union fees are being challenged. In the private sector, you'd have a question of whether state action applied, and therefore the rule of Janus would apply to that case.
I'm sorry. I thought that we had always recognized that the government as employer had a compelling interest in regulating its employment decisions. We permit the government to fire people, deprive them of all money, not just a fair share fee, but deprive them of any income if they speak outside of the government's approved policy messages or messages generally. So if we can permit the government as employer to have a compelling interest to do something as dramatic as firing someone, why can't that interest in having workplace peace, workplace routine in which issues are decided in a collective way, why isn't that a compelling interest comparable to the others?
Well, the government's interest in restricting speech don't apply to compelling support for speech. In fact, oftentimes they cut the opposite way. So the government's interest in restricting speech, for example, in the Hatch Act, restricting political activities, was in preventing the politicalization of the workforce and preventing government employees from being organized into a political machine. Of course, those same interests don't justify forcing individuals to support the speech of an advocate.
But that's no different than forcing student participation in fees to provide a public forum, to have a bar association regulated. These are all forcing the subsidization of private interest for a government purpose. And the government purpose here is labor relations and labor peace. Why isn't you still haven't told me why that's not a compelling state interest?
Well, irrespective of whether—
Or I shouldn't say state, a compelling federal government interest.
Yes, Your Honor. The Court doesn't need to reach whether or not labor peace and to that such interests are compelling, because agency fees are not a least restrictive means to satisfy any labor peace interest the government may have in listening to one union. So the labor peace interest, as this Court has explained it in Abood, is a government's interest in listening only to one union, so it doesn't have to listen to multiple.
Well, there's another way of doing student fees. You can have students who don't pay not participate in any student activity, because the price of being permitted to participate. You can have bar associations that the state runs. You can have alternatives of all kinds. But the question is the alternative that the state has chosen one that is well fitted to its need? Is it well tailored, narrowly tailored? I don't see how you can do that given the interest of the government in ensuring that unions represent everybody.
Well, an agency fee isn't necessary for exclusive representation.
Why not? You have free riding.
Well, the reason, Your Honor, is exclusive representation in and of itself is a valuable benefit for a union. It provides unions with extraordinary powers to compel the government to listen to it at the bargaining table, to not listen to other advocacy groups.
But it drains it of resources that make it an equal partner in the bargaining setting. If you are right, then it's not only the people who are opposed to the union, but also union supporters who may think, I'd rather keep the money in my own pocket. And then you'll have a union with diminished resources, not able to investigate what it should demand on the bargaining table, not equal to the employer that it faces.
Well, I think there's two things in that question, Your Honor. The first, the question is, does the duty to represent non-members raise union bargaining costs? And I submit that it does not. The unions, there's no reason why negotiating a contract for all employees in a unit would be more expensive than negotiating a contract just for the union members, because the union's discretion in bargaining is incredibly wide. And so the duty that the union has to the non-members, which it assumes over them by assuming exclusive representative authority, doesn't necessarily add any costs above and beyond what the union would already
But if you're not taking into account what I suggested, that it's not just the people who oppose the union, but the people who support the union, but say, we have a chance to get out of paying fees to the union. And so, although not for ideological reasons, we're going to pass, and we're not going to pay dues either.
Well, I submit, Your Honor, it's immaterial why an individual does not wish to support union advocacy. The First Amendment prohibits the government from probing into individual subjective beliefs.
So you're saying that you do then recognize that the unions can be in a position where they will be the resources available to them could be substantially diminished.
Well, to the degree to which the union resources are diminished by individuals exercising their First Amendment right not to subsidize that union, I submit that's a perfectly acceptable result.
Does the Constitution require states to demand that unions provide service? State law.
Yes. In state law, for example, in Illinois state law, there is a provision, the Illinois Labor Relations Act, that expressly provides a duty.
Yeah, I understand that. Is that constitutionally required?
No, Your Honor.
With reference to some of the other cases to discuss, have the unions at any point in this litigation or any point in their history ever said that they're committed to the idea of viewpoint neutrality?
No, Your Honor.
I wonder, since your time is limited, let me say three quick questions. What you're doing basically is trying to apply a more modern framework to some older cases. This has been the law for 50 years, just about. Okay? Holmes and Brandeis didn't know about these modern framework. How many cases? Should we go back? Do you think we should apply modern frameworks to all old cases? Begin with Marbury versus Madison? There are lots of very good lawyers in this room. They will think of all kinds of older cases where we haven't applied modern frameworks. So, one, what's your limiting principle there? Two, what is your limiting principle on the matter that we're talking about? I mean, Justice Stewart, who wrote Abood, in the 70s thought the case is identical or near identical to the Railway Labor Act cases. Railway Labor Act, that's the railroads. They're regulated. Government's involved, just as your clients are involved, just as the unions here. What's the distinction if you're going to try to make one? And really, three, and this is for all of you, all the lawyers here, what do you think of what I think of as a compromise put forth by Justices Kennedy, Scalia, Souter, and O'Connor in Lerner, called to our attention specifically by the brief of Professor Freed and Professor Post? Does that solve most of your problem for any side? Those are the three. You say? Stare decisis. Even if it weren't there, how do you distinguish all the other unions, particularly those in regulated industries? And three, what about the compromise?
Yes. So to address your questions in order, Justice Breyer, on the first point, Abood is not only inconsistent with cases that came after it, it was inconsistent with cases that came before it, such as Elrod. Even the dissent in Elrod, Justice Powell, would have applied exacting First Amendment scrutiny to patronage. So Abood wasn't just a departure or isn't just inconsistent with subsequent precedents, both the precedents that came before it. So this would not necessarily be solely applying a new doctrine to Abood, but applying what the law was even prior to Abood. With the Railway Labor Act, as this Court explained in Harris, there you have the private sector. You don't have the union dealing with government, which, of course, is political advocacy. And that political advocacy is subject to heightened First Amendment protection, which you don't necessarily have in the private sector. And then with respect to the third point, the test suggested in the dissent in Leonard, the problem with that is that it allowed for charging of collective bargaining and anything else that the government decided that the union had a duty to bargain over. So in other words, that test, the statutory duties test, allows the government to decide what is constitutionally chargeable under the First Amendment. So that test would, of course, among other things, allow for charging of collective bargaining. But here, collective bargaining is the core political activity which we submit individuals cannot be compelled to support.
Is it just the collective nature of the union? You're not suggesting that if an employee goes to the state and tries to negotiate his or her wages, that that's a First Amendment activity. We've said it's not, right?
Yes,
that
sir.
employment-related issues are not entitled to First Amendment protection, correct?
Yes, Your Honor, generally speaking.
So if an employee is disciplined by the state for some malfeasance, that's an employment-related issue not entitled to First Amendment protection?
Oftentimes.
Oftentimes. If employees come to the state and want greater training, employment issue, correct?
Generally, yes.
So why does it transform into some entitlement to First Amendment protection merely because a collective body of employees are coming to the table at once? What's the transformative nature now of making these substantive questions matters of public policy?
As this Court recognized in Harris, it's the scale. So here you have AFSCME bargaining over issues that affect hundreds of millions of dollars and affect thousands of employees across the board. The scale of that is what makes it a political
It's not going to change whether the union asks for it or the employees come. What you're now saying is if the employees came into an auditorium at a business site of the state and every one of them got up and said, I want higher wages, the scale of that demand makes it protected by the First Amendment? Still a work-related demand.
Well, in that hypothetical, it would arguably be a matter of public concern if there was a stage-in, at a public auditorium in which employees stood up.
Don't put in facts. They have permission to be in the auditorium. Okay. They walk in as a group. Every one of them gets up and says, I want higher wages. Is that an employment issue, or does that now become public policy because something that every employee wants, they've now articulated?
I would submit that it starts to move towards a matter of public policy if it isn't entirely.
So it's now scale, not subject.
Well, it's both scale and subject. Here the subject are wages, health insurance, many ways in which the government operates, which are very important both to the public fisc and to the operation and delivery of service.
Mr. Messenger, may I ask you about reliance interests here? I don't think that we have ever overruled a case where reliance interests are remotely as strong as they are here. So just a few things to put on the table. 23 states, the District of Columbia, Puerto Rico, all would have their statutes declared unconstitutional at once. Thousands of municipalities would have contracts invalidated. Those contracts probably cover millions, maybe up to over 10 million workers. So property and contract rights, the statutes of many states, and the livelihoods of millions of individuals affected all at once. When have we ever done something like that? What would be the justification for doing something like that?
Well, I'd say two things, Justice Kagan. The first is that the prevalence of these compulsory unionism provisions isn't reason for retaining Abood, it's reason for reversing Abood. You have wide-scale First Amendment violations, as you said, in 23 states.
Well, that would be to flip our usual stare decisis doctrine. Our usual stare decisis doctrine makes it quite clear that reliance is an important consideration on the scales.
Reliance on something that's constitutional, reliance on an illegal practice, no. For example, in Arizona v. Gantt, which involved searches of cars under the Fourth Amendment, the court said the fact this is occurring many places across the board is a reason for reversing it. Many individuals' Fourth Amendment rights are being violated. And so in that instance, the prevalence of compulsory unionism in the states is a reason for reversing it. And then in terms of contracts in general, I submit the contracts will survive, except for the excision of the compulsory unionism provisions due to severability.
Well, why is that? How many of these contracts have severability clauses? Do you know?
I couldn't find a number for the public sector, Your Honor, but most contracts, at least I've seen for anecdotal, do have severability clauses, and then the general rule under the Restatement of Contracts, I think it's 184.
California says the opposite. California has a whole brief there. You've read that.
Of course, yes, Your Honor.
So what's the answer to that?
The answer, Your Honor, is that I submit they're severable in California because they're not an essential provision of the contract that would require the excision of anything more than
Of course,
clause.
even if that's true, presumably they're bargained for provisions. The contract would have been different if the unions and the employers had known that this was going to be declared unconstitutional. So to leave the contract as is, except for one particular bargained for provision, is to do something that's inequitable for the union.
Well, I don't think that's necessarily always true as a legal matter. Foremost, in some states, compulsory unionism is mandated by the statute. For example, in California. And in other states, once the provision is there, it stays there. So it's not even a subject of bargaining usually. It's something that was always there from the prior contract. It's taken as an assumption. And even to the extent it was a bargain for issue in a recent contract, these contracts will expire the next 1 to 3 years and need to be renegotiated anyways. So I don't think that really changes the reliance interests. Mr. Chief Justice, if I can reserve the remainder of my time.
Thank you, counsel.
I submit, Your Honor, it's immaterial why an individual does not wish to support union advocacy. The First Amendment prohibits the government from probing into individual subjective beliefs.
So you're saying that you do then recognize that the unions can be in a position where they will be the resources available to them could be substantially diminished.
Well, to the degree to which the union resources are diminished by individuals exercising their First Amendment right not to subsidize that union, I submit that's a perfectly acceptable result.
Our usual stare decisis doctrine makes it quite clear that reliance is an important consideration on the scales.
Reliance on something that's constitutional, reliance on an illegal practice, no. For example, in Arizona v. Gantt, which involved searches of cars under the Fourth Amendment, the court said the fact this is occurring many places across the board is a reason for reversing it. Many individuals' Fourth Amendment rights are being violated. And so in that instance, the prevalence of compulsory unionism in the states is a reason for reversing it. And then in terms of contracts in general, I submit the contracts will survive, except for the excision of the compulsory unionism provisions.
The fees are the trade-off. Union security is the trade-off for no strikes. And so if you were to overrule Abood, you can raise an untold specter of labor unrest throughout the country. Thank you.
Thank you, counsel. 2 minutes remaining. Mr. Messenger.
Mr. Chief Justice, just to pick up on the last point made, the proposition that agency fees are the costs that employees have to pay to prevent unions from striking, I submit is not only extremely attenuated, but also would make agency fees effectively a form of protection money. The idea that the government needs to force its employees to subsidize unions or otherwise the unions will disrupt the government. And I submit that's not an interest that this Court can accept as a compelling one for infringing on individuals' First Amendment rights.
Welcome to the live. What? Oh, okay. You were just playing with me. You need it moved, or it's okay? You need it closer? Welcome to the Janus Q&A. I am Milton Chappell, Senior Staff Attorney with the National Right to Work Legal Defense Foundation. As you know, on June 27th, the United States Supreme Court decided the case of Janus versus AFSCME. My colleague, Bill Messenger, another attorney with the foundation, argued the case, and the foundation provided the legal assistance to Mr. Janus in bringing his case. As you also most likely know, Janus asked the court to overrule its 41-year-old precedent set in 1977 in the case of Abood versus Detroit Board of Education. That case also was brought by assistance from the National Right to Work Legal Defense Foundation. Back then, the court held that some fees could be forced from non-consenting non-members to support a labor organization if they were related to collective bargaining, but that overt political contributions could not be forced from a non-member. And so for 40 years, the foundation has fought over the meaning of what is known as chargeable and non-chargeable fees and the procedures that both unions and state employers must take to force the fees from non-members. All of that is over now because in Janus, the United States Supreme Court overturned the Abood decision and held that any forced fees from non-members is a violation of the non-members' First Amendment rights to free speech and free association. And the holding of Janus is most critical and probably provides the basis for the answers to most of the questions that I will be receiving today. Because of that, I want to read from Justice Alito's holding in Janus, which appears in the 7th section, section 7, of the majority opinion. A very good website link for you to review and get information is myjanusrights.org, www.myjanusrights.org. And on that site, in addition to getting all kinds of information and documents to use to claim your Janus rights, and I will be referencing that website throughout many of my answers, you will also be able to find a copy of the Janus decision. So, in Section 7, the court held, states and public sector unions may no longer extract agency fees from non-consenting employees. Neither an agency fee nor any other payments to the union may be deducted from a non-member's wages, nor may any other attempt be made to collect such payment unless the employee affirmatively consents to the payment. By agreeing to pay, non-members are waiving their First Amendment rights, and such a waiver cannot be presumed.
The problem is I have a...
You ready? Are we back on? Are we back? Okay, I think we're back. Sorry for those technical difficulties that just occurred. I'm ready for the first question, and here it comes. It's from Karen from New Hampshire. Thank you, Karen. She asks, my friend says she was told she had to wait until the collective... Ready? Should we go back and do the question again?
No, the question was okay.
Okay. In answer to your question, it is my best legal opinion that you do not have to wait until the end of the collective bargaining agreement to be able to resign your membership from the union. Let me just... Ready? You want me to go back?
I would summarize the question again.
Okay. The question that we got from Karen from New Hampshire was a question where she was told that, or her friend was told that she could not resign her union membership and take advantage of the Janus rights until the end of the collective bargaining agreement, which would be 2 years from now. And before I answer that means no. Now I see that questions are coming in, and let me just let you know that when I answer your question, I will be giving you my best legal opinion of what the answer is. However, it may be necessary to file a lawsuit or seek legal I see several questions have come in, so let's start with the first one. It's from Karen from New Hampshire. She writes, my friend says she was told she had to wait until the collective bargaining agreement expired before she could resign her membership. Is that true? That means we have to wait another 2 years. No, that is not true. My best legal opinion is that you have a First Amendment right to resign your membership in a union at any time. In fact, before the Janus decision was announced by the Supreme Court, 2 federal district courts, one in California, the other in Pennsylvania, had held that it was a violation of the First Amendment for a public employer and a union to require someone to remain a member of the union for any period of time. In other words, if you are not allowed to resign your membership at will, the union has violated your First Amendment rights. You should write and make the request anyway. If you go to myjanusrights.org, you will see sample letters that you can use to exercise your rights. You will see letters both for current union members, like the question that we just had, or for current non-members to claim their rights. If after you submit these letters, your requests are denied, you should go back to the myjanusrights.org page and go to the Need Help section and fill out the request for free legal assistance from the National Right to Work Legal Defense Foundation. The second question comes from Stephen in Pennsylvania. He asks, my district is already talking about going on strike this fall, just before school starts, because they are not getting what they want in the contract. I don't want to go on strike, but I don't want to cross a picket line either. What can I do? Should I wait to resign until they actually strike, or should I resign now? Well, Stephen, first of all, whether you resign and whether or when you resign is your personal decision. It's the choice that you have the right to make, and neither the government, the union, or even me can tell you what to do about that. but you have the legal right to resign now or to resign later. And again, the forms for resigning are on the myjanusrights.org website. Now, if you do not resign and you remain a union member, you do have a legal obligation as a member to follow the union's rule and to strike. And I know that you said that you do not want to cross the picket line, but if you did cross the picket line as a union member, the union can take disciplinary action against you and can even go into state court to enforce that. However, if you are a non-member, in other words, if you have resigned your union membership before you cross a picket line, the union has no legal power over you. If you do want to resign, you should resign the day before you actually cross the picket line. Again, I don't really have a legal answer to your question on whether you should resign now or whether you should wait until a strike is called. But clearly, if you do not want to participate in the strike or you do not want to be a union member, if the union does go on strike, you probably would want to resign sooner rather than later. John from California writes, my union rep is telling me I have to wait until the window period to drop my membership. Is this true? Well, John, your question is very much like Karen's question, and the answer is no. My best legal opinion is that you have a right to resign your union membership at any time. And as I mentioned earlier, a federal court in California has already held that it violates your First Amendment rights of association, which also includes your right not to associate with a union, to be restricted in your right to leave the union. The next question comes from Irene from Massachusetts. She asked, I pay the agency fee. I want to stop paying these people for something I don't want. What do I do? Well, first of all, if you are a public employee, the dues deduction should have already stopped. It is my understanding that most state attorney generals and state payroll officers have already sent out notifications to all public employers to stop the deductions. If your deductions have not stopped, then you can get a letter on the myjanusrights.org website. And it sounds like you mentioned you're paying agency fees, so it sounds like you're a non-member. So there is a letter for non-members to send in demanding both that the deductions cease and that you be repaid for any deductions that occurred after June 27th when the Janus decision was issued. Again, if the deductions continue, you should contact the foundation for free legal assistance. I see we have Sean writing in from Minnesota. Sean says, I'm a religious objector. What do I do to get my Janus rights? When I quit, will I receive all my dues back that I paid out over the year, or do I just have to be satisfied with them not taking any more out? That's a great question. First of all, as a religious objector, because Janus says that you do not have to pay at all, your religious beliefs of not supporting a union should be protected now that you cannot be required to pay anything. And this also means that you cannot be required to pay to a charity. Any payment to either a union directly or to a third party, including a charity, is now illegal, and you are free from having to do that. As far as the question as to whether all that you get is that the deductions stop, or do you get back the deductions, that is the huge open question. I believe that because of language in Janus, and because the court held that this is unconstitutional, that you do have a right to request the dues back or the fees back that you have paid, or even the monies you paid to a charity back from the union for the statute of limitations period that applies in your state. Basically, for most court actions, there is a limitations or a period for how far back you can go to get relief or to get money back. And so even though the Abood case was decided 41 years ago, and even though the Janus court overruled that, no one has the right to get the money back for the last 40 years. I wish they did, but that's not the way it works. In most states, the statute of limitations for a constitutional violation runs between 2 and 3 years. In some other states, it's less than that. Some other states, it's more than that. So my best legal opinion is that you do have the right to get back the money you paid for that limitations period. We're just going to refer to that for the last 2 or 3 years. Again, I do not expect any union to voluntarily give that money back. I hope I'm wrong. I hope I'm surprised. They really should do that voluntarily, but I don't expect that. So if you do want your money back, I think you are going to have to pursue legal action against the union to recover that money. And if you are interested in doing that, you should contact the foundation through the myjanusrights.org website to see if you can get foundation assistance to seek the return of that money. Chloe from Florida writes, what do I tell these union people if they want to come to my house and talk to me? I have no desire to join them in any way. Well, I think the simple answer is just say no. The union has no right to come to your house. You have every right to maintain your privacy and the protection of your home and to deny anyone the right to come there. So if the union says that they want to come visit, you politely tell them you're not interested. If they call you on the phone, you tell them that you're not interested and ask that they not call you again or that they not come to your home again. If you feel you are being harassed after you make these reasonable demands and that the union is pestering or stalking or continuing to come and ambush you, then again you should seek free legal advice from the National Right to Work Legal Defense Foundation. Oh, Susan from Maryland writes in, the union wants to have a required meeting with all teachers in the school. I don't want to hear it. Do I have to attend? Can the union make trouble for me if I don't attend? Well, Susan, my best legal opinion is that the public employer cannot force you to attend because I believe that that is also a violation of your First Amendment rights. But I don't want to risk your job and I don't want to see you be fired for not attending. So although I do not think you have to attend, again, you need to see what your employer says. I don't really care what the union says because they don't have the power over you to take your job. So if you are hearing from the union that there is a required meeting at your work site, you should first check with the employer. If that meeting is scheduled in the future, I would suggest that you seek immediate legal assistance from the National Right to Work Legal Defense Foundation to see if an attorney can represent you and speak to your employer and perhaps get you excused from that meeting. If you do have to go, please take good notes of what occurred, express your displeasure to both the union and the employer in being required to attend, and then contact the foundation. We, again, do not believe that you can constitutionally be required to attend such meetings. But again, as I've said in response to other questions, it may take a lawsuit to get that firmly established. Emily from Virginia writes, I live in a right-to-work state, but I don't want to be a part of the union anymore. If I resign, do I have to wait a certain amount of time or do it at a special time? Will I receive any refund of my dues? Well, again, it is my best legal opinion that you can resign at any time and that the union should recognize and accept your resignation immediately. Also, I believe that you have the right to revoke any dues authorization that you may have given your employer to deduct dues when you were a union member, and that your employer should stop the dues immediately upon your revocation or your request to stop the dues. And the union or the employer has no legal basis to take any kind of action against you for being a non-member. Martin from Florida writes, I also live in a right-to-work state. What does Janus do for non-members in a right-to-work state? It's a good question, Martin. And basically, Janus really doesn't do anything because a right-to-work state means that your state legislature has passed a law that has already given you the right to work or the right not to be forced as a condition of employment to pay money to a union. That is precisely what Janus has now done on a constitutional basis for the 22 non-right-to-work states where the state legislature had required or allowed public employers and unions to force non-members to support financially a union. So basically what Janus did was to make all states right to work, whether the legislature had passed right to work legislation or not, at least in the public sector. So I'm glad that you have been enjoying right to work protection in Florida for a long, long time. Actually, Florida's been a right to work state, I believe, for maybe 80 years or 60 years. And you can now know that the other public employees throughout the country are now free, like you are, to enjoy right to work, or as we call it, Janus rights. Well, I see we have another question coming. This is from Annie from Montana. She writes, I keep up my union membership because I won't have any liability insurance if I do not. Well, Annie, that is probably a myth that the union wants you to believe. Because first of all, while it is true that most unions provide liability insurance for their members, and when I talk about liability insurance, I'm talking about an insurance policy that protects you from lawsuits for doing your normal job. So this occurs a lot with teachers or the education profession. It also happens a lot in the medical profession. And so, unfortunately, it happens that teachers or nurses or doctors get sued by unhappy parents for students or patients for something that has happened. And so the unions provide liability insurance that protects their members from these lawsuits. Well, first of all, those lawsuits only cover you if you are following the direction of your employer. So let's go back to the teaching example. Let's say that in your school district, the school policy is that there is no corporal punishment. You cannot hit a child. And let's say that you happen to hit the child and you are now sued. Even if you are a union member, that liability policy is not going to protect you because you have not followed the school procedures, and that the liability is a cause of not following them. So first of all school districts have to provide you liability insurance for following their rules. So their policy, because they're going to be sued as well as you, would cover you. Now, I recognize that some people say, look, I don't trust my school district, I don't trust my principal, I don't trust my superintendent, and I want my own insurance policy that I can rely on. This, again, is a personal choice. So there are other sources that you can get the same kind of liability insurance that the union offers. A rider can be added to your homeowners or your renter's insurance to actually provide you liability insurance for your work. And many times that costs much less than the union dues. There are also some professional teacher organizations like the AAE or the Christian Educators Association International that provides liability insurance for their members. Those organizations are not labor unions, but they are professional education associations. And so, again, if you go to the My Janus Rights or the National Right to Work Legal Defense Foundation website, you will find information about where you can get liability insurance. So if that is the only reason that you are staying a union member and you decide that you can get insurance from another source, then you may want to go ahead and resign using the forms that we have on the MyJanus.org, myjanusrights.org website. Connie from Michigan asks, we've had people calling and emailing us with information about Janus. How do I know if this information they are giving out is correct? It's not being distributed by the unions. Well, I'm not sure I could tell you whether it's correct. So, of course, I believe that the myjanusrights.org website gives out accurate information and is probably the one that you should look at. Perhaps what you should do is compare it or just forget the other websites and go to our website. We are the organization that provided the legal assistance for the Janus case. You can hear from my colleague Bill Messenger about the whole case, and we believe that we know the case backwards and forwards and are committed to protecting your Janus rights. Ronnie from Delaware writes, is it any of the union's business why I resigned? They want me to give a reason. No, it is not any of their business why you resign. You have every right to just simply let them know that you are resigning your membership. Obviously, if you want to give them a reason, go right ahead. But you do not have to give them a reason. And if they are demanding a reason and will not process your resignation without you giving a reason, I believe, again, that that's a violation of your First Amendment rights. Pearl from Minnesota writes, this is a pretty heavy union state, and I've heard they are going to do all sorts of things to get you to join the union if you are paying the fair share fee now. Is there any particular things I should look out for when I resign, such as ways to get me to become a member or anything like that? Am I under any obligation to meet with union people to even listen to their spiel? Can I just say no? So if I resign, I understand I will lose all my member benefits and won't have any health insurance anymore. Is that true? What if the union wants me to sign their form when I resign? They tell me if I resign, I won't be protected anymore, that the district can fire me for no reason. I hear our crackpot governor is allowing unions to make their own opt-out rules, and that if we don't sign up to stop having our dues deducted during a window period, that we'll be paying for another year until the window period comes around again. Can they get away from that? Woo! Okay, there were a lot of questions there. So I'm going to see if we can go back and start those over again, and I'll try to provide the answers one at a time, because frankly, I don't remember them all. I do remember that some of the answers I probably have already given, but I would like to answer them all again, point by point with each question. So let's start this again. And I do remember your first set of questions basically going about that. Is there anything particular you should look out that the union is going to be trying very hard to have you join? Again, let me say that any person's decision to join or not join a union is their right. It is a right protected by our Constitution, okay? So the government should stay out of it, and that's what the Janus case is all about. No one should tell you to either be a union member or not to be a union member, and everyone should respect your right of whatever choice you make. So you need to look to see what they're saying they're going to do for you and then make a decision on whether you want to join or not. But be very careful at what they're promising you. You've been with them before. You've seen how they've worked in your workplace, and I think you can make an informed decision on whether they're really going to live up to what they are offering. At the end of the day, you need to be an informed consumer and make that decision. The bottom line is you can just say no. You are under no obligation to meet with union people, to listen to their spiel, or to join the union. And as I've said before, I believe that any requirement by the state or your public employer to meet with them or listen to them is a violation of your constitutional rights. But again, I don't want you to lose your job. And also, if they're coming to your home, you have a right to protect. Your home is your castle, and you have a right to decide who comes there. And so if you are being harassed, contact the foundation. Now, you also ask, if I resign, I understand I will lose all my member benefits and won't have any health insurance anymore. Is that true? Well, let me divide that answer up. True member-only benefits you will lose, but the union has a legal obligation to represent you under the benefits that are provided under the collective bargaining agreement. Most collective bargaining agreements provide health insurance, and neither the union nor the employer can discriminate between members and non-members of the union in what is provided in the collective bargaining agreement. So if you resign your union membership, you will not lose any benefits, including health insurance that's provided in the collective bargaining agreement. Now, I do know of some situations where unions have offered supplemental health benefits or other insurance benefits that are not provided in the collective bargaining agreement. If they are providing that, then obviously that is a union member benefit, and if you are no longer a member of the union, you can lose those insurance or might have to pay a higher premium. But again, I want to make a big distinction between the rights that are provided in your collective bargaining agreement, for which you cannot be denied as a non-member, and those that are supplemental or outside the collective bargaining agreement, for which the union may be providing a union member benefit. The next question was, what if the union wants me to sign a form when I resign? Again, I do not believe the union can require you to sign any specific form. Look at the form. If the form just simply says, I resign from the union, and you have no problem with what is on it, go ahead and sign it. Again, a form that we suggest you use is on the myjanusrights.org website that you can use. Again, if the union will not process your resignation, if you do not use their form and there's something in their form that you do not like, then that's a violation of your First Amendment rights in my best legal opinion. The other option you have is, if there are parts of the union form that you do not like, cross them out, go ahead and sign the form. You also have the right to ask the foundation to have one of its staff attorneys review the union form to see if there's any problems with it. Again, you can do that by going to the myjanusrights.org website. The next part of the question, the next question was, they tell me if I resign, I won't be protected anymore, and that the district can fire me for no reason. That is completely wrong. The district cannot fire you for any reason that is not put in the collective bargaining agreement. So most collective bargaining agreements have within them a restriction on the employer's right to discharge, and that it can only be done for cause. Again, you need to get your collective bargaining agreement, you need to look at it and see what it says. If, and I've never heard of this, your collective bargaining agreement has no restrictions on the employer's right to discharge you, then the employer may be able to discharge you, but cannot discharge you just because you are a non-member. because that would violate your First Amendment rights. I hear our crackpot governor is allowing unions to make their own opt-out rules, and that if we don't sign up to stop having our dues deducted during a window period, that we'll be paying for another year until the window period comes around again. We believe that that is unconstitutional. If there is a state law that says that, or a collective bargaining agreement, or any kind of restrictions in a dues deduction authorization form that you signed before Janus came out, that all of those are unconstitutional. But again, it may take a lawsuit to be allowed you to get out outside that window period. But in the meantime, let me make it very clear. Don't accept the union saying no or the employer saying no, and then you do nothing. If you are told no, you need to get the forms from our website, you need to send them in, you need to get a written no, and then you need to contact the foundation attorneys to learn what your legal rights or your legal options are, and to seek free legal aid to protect your constitutional rights. I may butcher your name here, and I apologize for that, but Perangula from Washington writes, I understand unions passed a law that allows them to get my personal cell phone number and home address. Is that legal? Well, I don't think it's legal, but the constitutionality of that has not been decided. And it may take a lawsuit to determine that. She goes on to ask, how can I tell if they have my, wait a minute, how can I prevent unions from pestering me at home and on my cell phone? Well, if they pester you by knocking on your door, you need to politely tell them you're not interested and request that they not come back. If they call you on your cell phone, you need to make the same request. My cell phone, I think most cell phones have a block caller feature, so you may want to block that number so they don't call you again. You also go on to ask, is that an invasion of privacy? I didn't even think the NSA can do that. Well, again, I personally believe it's an invasion of privacy, but the courts are somewhat over the map on how much information the government can have and what they can give out, and that is still being tested in the courts. Mike from Maine writes, I'm a union member now, but what if I change my mind and want to quit in, say, a year from now? That's fine. Janus and even the courts before Janus came out say you have a constitutional right as a public sector employee to resign your union membership at any time. The fact that you do not do it right after Janus came out doesn't mean that you lose your Janus rights. Janus is the law of the land. You have a constitutional right to be a non-member at any time, and as a non-member, you have the constitutional right not to be required to pay a union any amount of money or to pay a third party, like a charity, any amount of money because the union says so. And you can exercise those rights whenever you want. Marta from D.C. says, I'm so glad this decision came down, but can it be changed again so we have to start paying for union representation again? I haven't received any information from my school district or anyone else about resigning if I want to, or anything else about the Janus decision. I'm going to stop there and try to answer that question. In theory, just like the Supreme Court overruled Abood, in the Janus case, a future Supreme Court could change their mind again and unfortunately overrule Janus. We trust that does not happen, and elections are very important because the president chooses the members of the Supreme Court. So think about that when you're choosing who you are sending or choosing for president. So in theory, the answer unfortunately is yes, but we hope that it doesn't happen And the Janus decision went out of its way to point out how wrong Abood was, how Abood had not decided all the proper First Amendment law, and we think that that should support the Janus decision for many decades to come, if not forever. The fact that you haven't received anything from either your employer or the union about resigning is not shocking. There's nothing in Janus that requires the employer or the union to tell anyone about the Janus decision. That's why we have the myjanusrights.org website to educate people about their Janus rights. But just because they haven't told you anything about resigning or claiming your Janus rights doesn't mean that you cannot do that. Again, you can get the necessary paperwork from our website. You can go to our website to learn more about your Janus rights and how to exercise. I stopped the question at that point, and the question goes on as follows. Where do I start with going through the process of resigning? Well, you start with the myjanus.org website to get the form for union members to resign. You fill out that form, you process it, you mail it to the union and your employer, and hopefully, if they're going to follow the Constitution, they will honor your request and you will be enjoying your Janus rights in a couple of weeks. If they don't honor your request, then you should contact the foundation for legal assistance. You go on to ask, will it become effective immediately? It should be. Legally, it should. But what the union and your employer do, whether they want to continue to violate the Constitution, only they know. Will they stop taking my money immediately from my paycheck? That is what you're requesting in the letters that we supply. You are both resigning and you're canceling your dues deduction authorization, and you're requesting that as a non-member those deductions stop. There's two people that you're writing to. You're writing to the union and you are writing to the employer, and they both may take different responses, and so they should. Janus, in my legal opinion, requires them to stop the deductions immediately upon your resignation and your notice that you no longer are consenting to that deduction. But whether they do that or not, time will tell. And if they don't, please contact the foundation for legal assistance. We go on to, I don't know if this is a new question or the same question. It may be the same question. I read in an article that in Hawaii, that while the school district generally withholds union dues or agency fees, that the payroll department could not tell the difference between agency fee payers and union members, so they could stop deducting from non-members' paychecks. They were asking the union to identify the non-members, and it seemed the union was having trouble doing this. How can non-members have them stop deducting union dues? Good question. Well, first of all, the Janus decision technically does not require a non-member to do anything. It's self-executing, and it requires the public employers to stop the deductions from all non-members' paychecks immediately. But again, and the fact that the public employer doesn't know or the union's having trouble in figuring that out is no excuse, okay? But in that situation, clearly, this is the point. If you are a non-member and you are seeing deductions still being made for union dues that you have never authorized or consented to voluntarily, then you need to go to the myjanusrights.org website and go to the non-member form that you can submit. And you should send that in as quickly as possible. And then the employer, or in this case, the example of Hawaii, has no excuse not to know that you are a non-member and not to stop those deductions. And if they don't cease those deductions within a 2 or 3 week period, from you sending in the letter, you should contact the foundation for legal assistance. Nancy from Maryland writes, what can I do if they don't stop taking the money from my check, even though I've sent in a resignation letter? You need to go to the myjanusrights.org website, go to the part for legal assistance, and fill out that form and seek a foundation attorney to contact you to give you your legal options, and probably it will require a lawsuit for you to claim your constitutional rights, to have your request honored, and at the point, if it continues to be deducted, you would have a right to have the monies that have been deducted since Janus, if not before Janus as well, returned to you. Well, I believe that those are all the questions that have come in. Those are a lot of questions, and I really enjoyed answering them. And I hope that my answers have given you some idea about what your Janus rights are, how you can go about claiming your Janus rights, and what you need to do if either the employer or your union does not honor your Janus rights. Thanks again for tuning in, and we look forward to representing you.